Okay, so I guess we'll go ahead and begin our special edition of Legal Lines. So we'd like to welcome everybody today to Legal Lines. For those of you not familiar with Legal Lines, I am the host of Legal Lines, Glenn Smith. We are providing a special Legal Lines edition here today via Zoom, and we are addressing the issues of landlord tenant in the age of COVID. So again, we welcome you to Legal Lines. You can normally follow us on YouTube or on the White Rose channel for those living in the York County area. Legal Lines is brought to you by the York County Bar Foundation, and we thank them for their financial support as well as the other support that they provide. So before we get into the program, we do have a disclaimer that we would like to make clear for everyone, and we'll be repeating this throughout today's event. And I guess first of all is understanding the information that we're going to be giving here today in this webinar is for general guidance only. And what we mean by that is there's rapidly changing things happening here. In some cases, they're happening day to day, some cases even hour to hour. And because of the rapidly changing nature of this information, laws, rules, regulations, and other inherent hazards of electronic communication, there may be delays, omissions, or inaccuracies in information contained herein. Accordingly, the information in this session is provided with the understanding that the participants and publishers are not herein engaged in rendering legal, accounting, tax, or other professional advice and services. Before making any decision or taking any action, you should consult with a professional advisor. All right, so having said that, we are going to give you some instructions for following along here today. First of all, the webinar is being recorded. All of our viewers, we ask you to switch your screens to speaker view. That's going to make it a lot easier for you to follow along with the slides here today. And also select the side-by-side option. So if you go to speaker view, select side-by-side under the viewing options, you'll be able to see the presenter as well as the slides. Now, do note that this today is a test session as we are looking to get accreditation for distance learning. So we're hopeful that that's going to be going through, but this is a test session. And as part of that test, there will be 2 single non-related questions posed during the presentation and an evaluation poll at the end of the program. It's important for you to complete all 3 items as they pop up on your screens. That is as part of the accreditation process. All of you are on mute, with the exception of our 2 presenters that I'm going to be introducing here shortly, as well as myself. Therefore, we ask that you use the chat feature, which is located at the bottom of your screen. All right, you can in there pose your questions to the group, and I will be doing my best to keep track of the questions as they come up so that we can answer those at the end of the program. Do note for your questions, we ask that they be of a general nature. What that means is do not include, Joe Smith did this or the property located at 123 Main Street. We ask you to please keep it as generic as possible so as not to identify individuals, properties, or locations. As I indicated, we will do our best to answer all of your questions at the end of the program, so do stay with us. And following the webinar, a link will be provided for everyone that had registered, giving you the recording as well as up-to-dates on any questions that we were not able to address. Okay, so let's get to our presenters. Today, we are very fortunate to have 2 gentlemen with us here today that are going to be providing the views of landlords as well as tenants. So I expect to have a very well-balanced conversation here today, addressing both sides of the proverbial table. Our first presenter is Kurt Blake, and Kurt has been a landlord attorney since 1993. He teaches statewide at the Magisterial District Judge continuing education classes on landlord tenant, and he's been doing that since 2009. He's also licensed as a real estate broker and a title insurance. So Kurt, welcome.
Thank you. Thank you for having me.
All right, now we also have Matt Rich with us, and Matt's an attorney with MidPenn Legal Services, and he's in their Harrisburg office, and he provides advice and represents low-income residents in the mid-state, mostly in Dauphin and Perry counties, primarily areas of landlord tenant, both in private and subsidized housing matters. Welcome to you as well.
Thank you for that, Glenn.
All right, so as we mentioned at the beginning, we are in a very unique time here today. We are facing rapidly changing events, in some cases, day to day, hour to hour, and the information we're providing here today is current as of today's date, the date of this presentation being April 30th of 2020. So we do suggest past today's date to do additional research, whether that's consulting with an attorney or what have you. Now, some of the information we're providing here today in this instance is regarding the Pennsylvania Supreme Court order, and that closes all Pennsylvania courts extended through June 1st. Now, in addition to the Pennsylvania Supreme Court orders, most locals, meaning the counties, have also issued their own particular orders, and we will do our best to talk to some of those as well. Kurt primarily practicing in York County, and Matt being up in the Dauphin and Perry County areas. So Matt, let's talk a little bit about this Pennsylvania Supreme Court order and what's happened, what has been done.
So I think one thing that's important to understand here, folks, is that there are, I think, two primary objectives, especially as they relate to landlord-tenant matters, that the court was taking into account, and two primary purposes they wanted to serve when issuing this order. The first is that we wanted to make sure to shut down the courts, whether it be the Supreme Court, the minor courts, so that we didn't have large gathering of folks. Now, that does include an exception for a few essential functions, such as protection from abuse orders and criminal matters. Those are still occurring, obviously practicing safe distancing at those proceedings, but those are still occurring. But for the most part, the intention of the order is to make sure that we don't have folks crowding into courtrooms unless it's an essential function. The second thing that the court took into account when they issued the original order and the supplemental orders is that we wanted to make sure that folks were not being physically evicted from properties during this health crisis. And I think that's a good way, if you can keep those two kind of key points in mind, I think that's a good framework to work with as we're trying to analyze these orders and what they mean and how we should be operating pursuant to those orders. Now, the closure includes, as I say, from the Supreme Court, includes courts of common pleas and magisterial district judge offices. The only concrete change to operations that's been applied as of right now is that the current restrictions on eviction actions and enforcement of payment obligations have been lifted as of May 11th. One caveat that I'm going to throw out there is that each county, as we mentioned, and as is alluded to here, each county had the ability initially to enact their own order, which is meant to work in conjunction with, but which may contain different terms from the Supreme Court's order. So, for instance, we're going to use York County as an example throughout here today, since this is put on by the York County Bar. But we're also going to then reference the most recent Supreme Court order, which was just issued yesterday afternoon. The Supreme Court order, the York County order, for instance, closes courts through May 31st, but we have to keep in mind that the Supreme Court order has now, with regard to landlord-tenant matters, made May 11th the date that we need to keep in mind with regard to evictions. But the court closures, the emergency statewide, and in most counties, most counties have their own order that dictated out to May 31st. But even if the county doesn't have an order dictating out to May 31st, the Supreme Court order dictates that there's a statewide emergency and closure until May 31st. But we do have to keep in mind and be leery of this May 11th deadline as it relates to landlord-tenant matters, which we're going to touch on here.
Okay, thank you, Matt. So the Supreme Court order also includes a moratorium, which in other words is a freezing of evictions for non-payments of rent during the time that the courts are closed. Kurt, can you talk a little bit about what that means for tenants who are or may be facing eviction at this time?
Yeah, certainly. I think it's important. We'll do a quick overview of the eviction process. And this is all based on non-Section 8 eviction proceedings at this point in time. Victoria, can we get to the next screen then? All right. So when we have an eviction proceeding, typically most landlords are using a written lease which waives what's called notice to quit, or the notice of a violation or default or a problem. And it gives them the opportunity to go to magisterial courts and file that landlord tenant proceeding. When they do that, they're supposed to have a hearing somewhere within 10 to 14 days. And then that lockout that we all hear about would not happen for at least 21 days after that. So there's a 5-week time period. If on May 11th or May 12th, a landlord went in and filed, 5 weeks at a minimum is a time period before a lockout would happen. What we're going to talk about on this slide is what if we had a pending case? So if I filed prior to the Supreme Court's orders freezing or putting a moratorium in place, essentially what I see happening now is that magisterial courts are now effective to say, let's get these things scheduled, let's get these things moving. If there's lockouts that were pending from a case that was completed, that we can now either get this time started towards the time periods in play, or that we can actually get them scheduled. Just so everybody that's listening understands, if I go to a court, let's say I go to a magisterial court on an eviction proceeding, and I have my hearing, and I get a judgment for rent outstanding, and the judge gives me that dollar amount in the possession order. There's a 10-day time period for the appeal, and on the 11th day, if there's no appeal, then I can go and file for my possession, which takes another 10 days to get it. The argument a lot of times is that there's been this sort of holding pattern or period here that's held up some of those time periods. So this opening up on May 11th now lets these time periods start moving forward, let us start getting forward. There's a second component. If a tenant appealed a case to the magisterial court, or if the landlord started at the Court of Common Pleas, there are time periods there that now, as of May 11th, we can start moving this thing forward as far as requiring answers, getting it listed for hearings or the such. So there's a little bit of different scenario, but the majority of cases all start at the magisterial district court on the residential cases.
And one thing, if I can jump in there just really quickly to frame this a little bit as we move forward, because you'll see these comments at the end of each of these blocks here where we talk about same in York County but maybe different in other counties. I want to go back to what I had touched on the previous screen and really put this disclaimer out there, because, and I might do this on every slide, frankly. There's been very little, as far as I'm aware, perhaps even no guidance from the Supreme Court and the AOPC to go down to the county courts as to how they are to operate within the confines of the Supreme Court order. So what I have found through asking around as widely as I can ask, I have found that the general consensus is that there are different things happening in different counties. And that goes to the wording of orders from the counties and them determining what they can and cannot do in the context of the Supreme Court order. That comes from even the county court level and the Court of Common Pleas down to some MDJ's offices, because the language of the order might say one thing, but MDJ's may perhaps be interpreting it to say that we need to close this down. So for instance, to put it into context here for today's purposes, the court order in York County closes the court through all courts through the end of May 31st. But what the president judge of York County had put out to all the Bar Association and the court is that their understanding of the Supreme Court order that was just issued is that because the Supreme Court order has said that these dispossession of property suspensions need to open up on May 11th, York County has then adopted the position that although the courts will remain closed to the public until the end of May, as far as the processing of landlord tenant cases is concerned, they need to open back up as of May 11th. And again, that's the status of it right now. That could potentially change later today, tomorrow, what have you. The most imperative thing that I can put out there to you folks is whatever county it is that you're operating in, the best that you can do is try to contact either the magisterial district judge's office in question to contact a legal professional in that county to try to get someone to explain to you how it is that your particular county is operating at this time, because it's too difficult for us today to be able to try to put a blanket on this for everyone. Okay.
I think it's also important to note that not one of these orders is saying to the tenant, don't pay their rent. They're just saying the landlord can't take the steps to enforce it when they don't pay.
Yep. And we're going to come back to that later when we talk about best practices for tenants.
All right, so the next one we have, we're at this screen. So what we have is what we're facing now is if we have a landlord that's already filed their eviction, they're at the magisterial courts, they're at the common pleas. The argument then is we can start moving these things forward, getting our orders for possession from the cases we had back in February. If with the Court of Common Pleas, we could start filing to terminate if people haven't made their rent payments and really get these things moving along again that have all really sat stagnant, not been able to move. So we have a couple of things. One is that the landlords can either get moving forward filing these cases, or if they've already filed them, they've just been stayed, we can start getting them scheduled expeditiously. And then the third is if they've already gone through the process, possession is pending, we have the opportunity to get the constable or the sheriff doing the possession portion. So it's going to open up come May 11th.
Again, with the caveat to check with your particular county, though,
Right.
because we, as I say again, if we're taking a conservative approach to this, what I have been doing is I've been talking with my fellow advocates and talking with our clients is I've been counseling them to expect May 11th. But for instance, in Dauphin County, I just spoke with one of our judges there today who said that he had the only guidance that he had received was that everything was to be shut down through the end of May. And unless and until he gets any other further guidance, despite what the Supreme Court order said, he was still going to push everything off until on after June 1st. So it really, really is a matter of just checking with what's going on locally for you.
Okay, so everyone should see at this point, there should be a screen that has popped up regarding participation question number 1. So if you could please take a brief moment to complete that. As we indicated as part of our test session here today for accreditation with distance learning, this is part of the necessary process. So we appreciate your participation.
I've seen some folks indicate that it popped up and disappeared. It hopefully should be back up for folks now.
Well, I'm jealous of the 5 saying the sun is shining wherever they are. So
Where are they at?
We need to move the location of the next one, I guess.
that's right. Wherever they are, we're heading. So.
Okay, so it looks like polling is closed now, Glenn. I think we can segue into our next slide.
All righty. So Victoria, are we good to close out that poll then? I have it on my screen.
It's closed.
Okay, very good. I'll close that out. Thank you. And Kurt, let's get back to the moratorium. So we're in the midst of the moratorium. Where are we with renters and tenants who may be facing eviction at this time?
Sure. Sort of the overall summary, just since we had that poll jump in there, would be come the end of May 11th, we're either going to be getting these things, the landlord has the ability to go and file. And with that said, I'm not suggesting every landlord I represent that they run out in the 12th and file. There are a lot of landlords that are taking a very compassionate step. They're working with their tenants. They're reaching out to them. They're setting up payment plans, forbearance agreements. But there are also a lot of landlords that had cases starting back in January and February for non-payment that goes back 5 and 6 months ago, and it's continued. A lot of them have the ability, if they haven't filed, jump in and start the filing. If they had filed, continue that now, getting it scheduled. And if they've completed the filing, the hearing process, the appeals are over, that they can now move this thing forward for possession. Of course, back to that caveat we've had, we're looking at May 11th, moving it forward in York County, some other counties. Many counties will be the end of the month come June 1st time period. If we're in the common pleas court, certainly that just allows the case to move forward under the normal rules and processes that are involved there.
All right, so before we move on to this next part, just as a reminder, we are accepting questions. We ask you to send them through the chat box down at the bottom of your screen, and we ask you as we're going through this to please do those so we can accumulate them for the end of our program. So Matt, let's go back to you. And one of the things you hear about in landlord tenant law, and we're going to talk a little bit about it right now, is self-help. What does self-help mean?
Yeah, so what self-help means generally is a property owner or landlord taking steps on his or her own to evict an individual outside of the prescribed legal process through the court system. So, some examples of that is shutting off essential utilities. I hadn't seen it so much recently, but in times past, we would see landlords literally coming and removing doors off of hinges, etc. And so those sorts of things are and have been for decades and decades now patently illegal. It does get a little bit questionable at times when you run into these rooming house and boarding house scenarios or long-term stay hotels, motels. And I know that I've heard from some service providers throughout the state that has been called into question, in particular with the folks that are working with homeless populations that are trying to work with hotels and motels to get a system put in place where they can pull the homeless folks off of the street and put them into some sort of shelter program as a result of trying to deal with this health crisis. But what we want to touch on right here is just to make it clear to folks who might not know. I understand it is certainly a frustrating time for landlords, especially for those that are not large outfits and that are working on tight margins. But it is important to understand that the only appropriate way for a landlord to evict someone is to take the appropriate legal action, which would then result in an eviction by a constable, which is at the end of an MDJ eviction process, or by a sheriff, which would be at the end of a court of common pleas eviction or ejectment process. And so what we've been trying to put out there is a call to folks that if you are a tenant and you have a property owner or landlord who is trying to change your locks, remove your door, shutting off essential utilities, your best practice would be to call 911 first. And then the local legal aid office immediately. So we have our York office, York MidPenn Legal Services office numbers there. Just know, folks, especially because I know that we're, I think, have some folks on here from across the state. There is a legal aid office that covers every county in Pennsylvania. We may go by different names because there are different companies that operate in different areas of the state, but there's always a legal aid office that covers every county. It's just a matter of identifying which one. But if you're in New York, it's MidPenn Legal Services, and there's our office number to reach us directly if you run into this problem.
Thank you, Matt. So we're going to change gears at this point. Up to this point, we've been talking about your typical standard landlord-tenant relationships, and now we're going to move into a different part of that, and this applies to the CARES Act, which stands for the Coronavirus Aid, Relief, and Economic Securities Act. So this part of the program deals with certain types of federally subsidized housing. So it's going to be specific in that respect. So Matt, can you talk a little bit more about what the CARES Act provides and how is it important in today's scenario? And I'm sorry, it was, or I apologize if we're having Kurt. I had, Matt, are you speaking on this one?
Yeah, you got it. Yep, this is
okay,
fine. I'll take it and go around. Thanks. So as we transition into the next slide here, one thing that I want to touch on up front to frame this discussion is that although I've seen the numbers differ, I think somewhere around 1/3 of all housing units in America is subsidized in some way, shape, or form by the federal government, whether that be through direct subsidies and programs that we're going to discuss, or whether it be kind of, say, maybe indirectly by federally insuring certain mortgages. So it's not like a vast majority of the population, but certainly a large enough number that we do need to be cognizant of these federal subsidies. And we're going to get to the outline of all of the different subsidies that are in play and that come under the purview of the CARES Act. But we're touching in this portion about just the subsidized housing aspect, because that's what the CARES Act applies to. So now what's important to note here, the most important provisions of the CARES Act with regard to renters and tenants and subsidized landlords. Beginning on March 27th, there is a 120-day moratorium on evictions for non-payment of rent for tenants that live in certain types of federally subsidized housing, which we're going to get to in a second. So if the landlord gave an eviction notice for merely non-payment of rent before March 27th and did not file a complaint, then the landlord cannot file that complaint at the magisterial district judge's office or in the court of common pleas until on or after the moratorium ends, which is July 25th. Furthermore, during this time, during the moratorium, a landlord cannot charge late fees or other charges related to non-payment of rent until on or after July 25th. Now, as we move into now, if a tenant currently owes money for rent, fees, or other charges to the landlord, but the landlord's yet to even serve an eviction notice, then the landlord cannot give that eviction notice during the moratorium. So not until on or after July 25th. And again, keep in mind, that's for non-payment of rent, as opposed to other issues, which we'll touch on in a sec. So also, if and when the landlord serves the tenant with the eviction notice for non-payment, that notice is required to be a 30-day written notice to vacate before the landlord can file the complaint at the magisterial district judge's office or in the court of common pleas. So again, if you haven't served a notice and one of your tenants has run into a non-payment of rent issue during the moratorium, you have to wait until on or after July 25th to serve the notice. It has to be a 30-day notice. So then you'd be filing at the MDJ's office or in the court of common pleas sometime around the end of August. Now, the natural next question then is, so to which properties, to which housing does the CARES Act apply? Now, this is not an all-inclusive list. I tried to pull out what I thought were maybe kind of the more common housing subsidies that come into play. There are some others, but this is, I think, the most common types of housing that we're going to see that fall under the purview of the CARES Act. So first, we have public housing subsidized by Department of Housing and Urban Development. So you're going to hear me use the acronym HUD. Section 8 Housing Choice Voucher Program, which is the tenant-based subsidy from HUD. Then there's the Section 8 project-based housing through HUD, which again is the subsidy attached to the unit, the project. Section 202 housing for the elderly, HUD program. Section 811 housing for people with disabilities, HUD program. The Low Income Housing Tax Credit Program, LIHTC. Section 515 rural rental housing for the rural portions of our state. And then the other, and the final thing I throw in there, and this is where it gets a bit tricky, which we're going to touch on, properties with federally backed mortgages. So even properties that are privately owned by individuals or companies, if they have a federally backed mortgage, they also fall under the purview of the CARES Act.
Now that doesn't necessarily apply in every situation, right, Matt?
Yep, so now we want to touch on, and Victoria, we'll head back to that slide, sorry about that. But yeah, so now we want to touch on the three cases that have been pulled out where the CARES Act does not apply. So if you have a case that was filed before the moratorium took effect, right? So if you're a landlord and you filed a complaint for non-payment towards the end of March, or more than likely would have been towards the middle of March or beginning of March, and then you probably got continued by the state moratoriums. As soon as March 27th rolled around, the federal moratorium came into play. If you had a case pending before the moratorium took effect, you do not have to start all over again. That case will continue to process, again, based on those state and local moratoriums coming into play and being ferreted out. But you don't have to start all over if you already had a case started before the moratorium took effect. It also does not involve cases that have in play non-covered tenancies. So the list that I have provided you, and again, it's the more encompassing list. If this helps for any of the folks that are on the call, is that the CARES Act applies to any properties that are subject to the protections of VAWA, the Violence Against Women's Act. So even if you didn't see your property listed on that list there, if you're subject to VAWA, if you're familiar with that, you're a covered tenancy. Now, if you are in a property that is not covered, right? So if we're talking about a strict privately owned property where there is no federally backed mortgage, then the CARES Act does not apply. So again, in the context of the whole nation, we paint with a wide brush, it's about a third of all properties are covered, and then about 2/3 are not covered. And then the last issue or last scenario that is not covered by the CARES Act is cases involving eviction that's based on another reason beside non-payment of rent, other fees, or charges, right? So again, we keep in mind kind of the purpose behind this is to the federal government recognize that many folks have lost income and are going to struggle to regain income during this crisis. And so the notion is that we want to protect folks that are not able to work and are not able to get back to work, don't have income, so that we're not throwing them out onto the street, especially when we're in the middle of this health crisis. But the government did not take into account the folks that are doing things that are breaching their leases for other reasons. So if we have illegal activity in the unit or unauthorized occupants, those are reasons that you would still be able to proceed as a landlord, and as a tenant, you would not have this coverage for, despite the coverage for the non-payment of rent.
Hey, Matt, as you know, I've been an advocate for years of a month-to-month lease scenario with landlords. What's your take on this? If I'm in a month-to-month and just give notice I'm not renewing, I take the position that terminated or ended lease.
Yes. So one note that I was actually going to throw in there, and you're good prescient there, Kurt, is that one of the things that as a tenant advocate that we're looking and being cognizant of is that the ulterior motive scenario, right? So if it's an end of a lease term, if it is trying to bring up some illegal activity or some other breach of the lease, but it's clear to all involved that the true motive behind the eviction is non-payment of rent. So even in your scenario, Kurt, if it is just simply terminating the lease or not renewing the lease, if the reason is for non-payment of rent, then that is something that tenants advocates are surely going to be latching on to argue against. So if you had a month-to-month lease, if there was no rent being owed and you didn't want to renew it, I think you would probably be able to get through. But if it's clear that you're not renewing a lease simply because they're not paying, then I think that that would frustrate the purpose of the act, and you'd have me in there arguing with you about it. Does that seem fair to you?
Well, I think you and I can agree to disagree, as we often do. I'm an advocate at a month-to-month because it gives me opportunities when I have issues with tenants, whatever they may be, that I can easily terminate and not get into credibility or witnesses or things of that nature. So
I think
I understand.
Perfect example, gentlemen, of where we are in today's climate. There's so much that we don't know how it's going to handle because we are in uncertain times, particularly in the legal arena. Fair?
Absolutely.
Absolutely, yeah. And again, as you mentioned early on, Glenn, we want to keep coming back to things changing all of the time as well. So we are on the fly learning things, trying to digest them, and then trying to spit out arguments on the back end. So it could.
Yeah,
change.
I mean, Matt and I talked about a scenario yesterday in preparing for this. What if you had a multi-unit housing scenario and they have a mixed use, and we don't have any of the other criteria, but there's 20 units and unit 1 has a Section 8 tenant, and the remaining 19 are not Section 8 tenants. The argument we talked about is there an argument from a tenant base to say units 2 through 20 can't be evicted because there's already a Section 8 protection person there? I don't think it translates to every other tenant to protection. I think it's tenant specific. But I think that's another one where we're going to see the tenant advocates and the landlord advocates take different positions.
And so the point Kurt's getting to for any of the landlords on the call, and something that I think you should be cognizant of, is that the notion is if you own a property, even if it's mixed use, if you have any federal money flowing into your property, then there's a high likelihood that the CARES Act is going to apply. There may be some instances where it may not, but they're likely to be limited. And I think that the thing that you should be cognizant of and be keeping in mind if you have any kind of federal money coming in, flowing into your property in one form or another, is that you should be leery of this, and you should be consulting with your solicitor or your attorney prior to taking legal action.
So Matt, you've kind of touched base with the next part of our conversation here today, and is how do we figure out whether or not a tenancy qualifies for protection under the CARES Act?
And what I'll say as we're transitioning to the next slide here is that this is, I think, going to be the most difficult thing from a tenant's perspective to try to work with. And I say that because, and I think Kurt will agree with me on this, is that in the majority of cases, the landlord is going to be the party who has the information available to him or her to know whether or not the CARES Act applies. In very rare instances is a tenant going to have access to that information that's needed to be able to determine whether or not the CARES Act applies. So now what we've done here with this slide is we've tried to identify, though, for tenants what you can be looking for, or even landlords, what you can be looking for to try to identify whether or not the CARES Act applies. Now this slide in particular is with regard to project-based subsidies. So subsidies that are attached to the unit itself as opposed to the tenant, which we'll hit on the next one. So one of the things we're look at the lease agreement, especially if you have a property where there is a prescribed lease addendum, like in tax credit properties. If you see a lease with a lease addendum that talks about LIHTC, that can be an indication that the CARES Act applies. Look to see whether you do annual recertification documents, right? In the vast majority, or maybe all of federally subsidized housing, there's a requirement that the tenant recertify their household and their income on an annual basis. If you have annual recertification documents with either the landlord directly or with a local housing authority, that may be a good indication that the CARES Act applies. You can search the National Housing Preservation Database website. We have a link there. That's a searchable tool that you can utilize to try to search for your particular property and see if it qualifies. There's also the Pennsylvania Housing Finance Agency's rental housing inventory, or inventory of affordable housing, that is posted on their renters page. If you go to the phfa.org website, that's a good resource that we can try to use. But these are all very general in nature, right? These aren't specifics necessarily. These are pretty general, as you might be able to deduce from this. But these are good tools that tenants might be able to use if they're not able to get the information from the landlord, and some landlords might be able to use if you don't know offhand. So the next slide then talks about tenant-based subsidies. So if you have a Section 8 housing choice voucher where the subsidy is attached to you as the tenant as opposed to the building itself. So what we're looking for there is, again, look at the lease agreement. Is there a lease addendum? Is there anything that might help you identify that you are dealing with a federal subsidy? And then look again to see whether or not you're performing annual recertification documents, especially with the Section 8 Housing Choice Voucher Program. That's a program where, again, the tenants are required to recertify every year with the housing authority. So while they might not recertify with the landlord, if it's a private landlord that's just renting out to a Section 8 tenant, they might not do anything with the landlord specifically, but they would recertify each year with the housing authority. So if you see that in play, that's another telltale sign that the CARES Act comes into play. And then Victoria, I think we're ready for the next. Oh, it looks like we're ready for a question.
Okay, looks like we have our second question here. And again, we appreciate your participation in this as part of our test for accreditation on distance learning. So this will just take a moment. Looks like everybody's hopping on this one a lot quicker.
And something tells me they might be more interested in this than some of the subject matter. This is a hot topic, Coke or Pepsi.
Hey, Matt, these at least keep them awake.
Yes,
Okay,
absolutely.
so at this time, Coke is in the lead, followed quickly by Pepsi. We're heading into the home stretch here. Coke still has the lead. Pepsi is dragging way behind.
I see here the vast majority of folks have this dead wrong.
You know, Matt, again, you're on the wrong side of things.
We have Coke over Pepsi.
Yeah, I was going to say, as soon as I said that, something told me, Kurt, that you'd be choosing Coke.
All right, so we are back in. All right, so I believe we have some additional resources contained in the program, but we are going to be moving on here. Let's see, federally backed mortgages, we have some additional sources here for you to check out.
Yep, and so now this is, again, this is to me, I think, where it's going to be trickiest for all involved, whether it be landlords or tenants, especially tenants, but even landlords as well, is to try and understand whether or not the CARES Act applies to you if you have a federally backed mortgage, right? So this is from the tenant's perspective, right? So the first thing that we try to get tenants to do is to ask the landlord, and if you're going to ask the landlord, it's best to do it in writing if possible. So, you know, just a simple ask, you know, hey, do you have a federally backed mortgage? Does the CARES Act apply? Now, we fully understand there may be situations where perhaps even the landlord doesn't know that offhand. Or you, even as a property owner, you might think you have a good grasp on it, but you might not realize that your mortgage has been sold 10 times over since you purchased the property. And so you might not have checked in on it or have a good grasp on that. So two other options is to call Fannie Mae, and the information is provided there, or to call Freddie Mac, and the information is provided there. Now, understand, from the tenant's perspective, the tenant would need a lot of information, and particular information, about the property and about the landlord in particular. And especially, they would need to know either that EIN or TIN is the employer identification number, or the taxpayer identification number, in order to use these lookup tools. So this goes back to the premise that I laid out originally, which is that in these instances, the property owner is going to be the one who's going to have a much easier and better time of being able to try to track down this information than a tenant is going to be able to try to track down. I think that's going to be very difficult for tenants in these scenarios unless they've got a great relationship, open relationship with their landlord, that they can ask their landlord and the landlord provides them everything that they need, which I don't know that most landlords will be willing to even provide. And then the tenant tries to take that information and call Fannie Mae and Freddie Mac. I think this is mostly then geared towards the landlords looking these properties up. And Kurt, can you chime in on that and give me your thought?
I guess the first point is we're not exactly sure how the courts are going to require this information to come into play. Whether or not a landlord's going to have to make that part of their case and say, I don't fit it, or whether it's a defense for the tenant, that's something we'll see play out. As to mortgages, I did a quick look at Recorder of Deeds today online and just double checked. If a landlord were to look at their mortgage, or if someone wanted to, it's all public record at the Recorder of Deeds. Typically now you're going to see a Fannie Mae or a Freddie Mac kind of loan. It's going to have that on the very bottom left-hand corner of the mortgage stated. It's a uniform document. It's Fannie Mae, Freddie Mac type of scenario. And a lot of clients, I've just been suggesting, and most of them, contact their banker, get an email or letter from the banker saying that, you know, it's not a federally backed mortgage scenario, and we're very clear to go. If someone bought a house and they did it FHA or VA or something like that as their primary home, and then they bought a second one and moved on, then we know right off the bat that's more than likely a federally backed style loan. But mortgage, the apartment complexes, the larger commercial guys that are doing blanket mortgages, most of those, in checking with our local banks, are telling me they are not federally backed mortgages.
And where I'll leave this before we move on to the next slide is just, I think in the coming days or a week or so, I do think that folks, whether it be tenants or landlords in particular, I do think that there's going to be some additional guidance that's going to come out in one form or another that is going to require landlords in some way to disclose this on new filings. So if you go to file a complaint as a landlord, It may, be a separate form that you have to complete. There may be documents that you have to attach. It may just be checking off some boxes. We'll see how that's going to play out exactly, but I do think you should be cognizant, especially as a property owner, that when you go to file a new case here, again, between now and July 25th, while the moratorium's in effect, there's going to be some work to be done for you to be able to show that you're not covered under the CARES Act.
Okay, gentlemen, well, thanks so much for that. We're getting towards the end of our program, but before we get to the questions part of it, and if you haven't already submitted your questions, we are asking you to do so through the chat box, which is located at the bottom of your screen. So before we get to that, let's talk about some best practices. What are some of the recommendations or suggestions that we have for people right now?
So I can say, again, from the tenant's perspective especially, and that's what this slide is kind of geared towards, is that if you are able to do so as a tenant, you should pay your rent, continue to keep paying your rent, or if you have fallen behind or had a lull, if you can get caught up on your rent as you normally would, regardless of either of these moratoriums, whether it be the state moratorium, the local moratorium, or even the federal moratorium, because as of right now, there's been no indication anywhere across the board, whether at the federal level, state level, local level, that any rent that is not paid during this time will not be owed to the landlord when all is said and done. The moratorium only means that the landlord cannot move forward with the eviction during this time because of the health crisis. It does not necessarily mean that your landlord's not going to be able to pursue eviction as soon as this moratorium ends. And as we were discussing earlier, unless and until something changes in the coming days or week or so here, we might see this moratorium end in some instances as soon as May 11th. So if you're able to pay your rent, get caught up on your rent, you should do that. Now, if you're not able to, one of the things that we've been trying to advise folks to do is, if at all possible, contact your landlord, discuss the situation with your landlord, see whether there's any type of agreement that can be reached where you can work around your particular circumstances. My advice has always been, even before this, an open line of communications about such things seems to be the best practice. I think where I've seen landlords, and I'm going to throw it to you in a second, Kurt, on this, I think where I've seen landlords struggle with trying to work with folks in most cases is when they don't hear anything, right? I mean, it's better, even if you don't have anything great to say, it's better to at least say something and let the landlord know that you're working on it than to just simply duck your head in the sand and ignore your landlord, because in those instances, I think in most cases, the landlord's likely to assume the worst. So Kurt, can you maybe jump in here and give some perspective on what you've been talking with your landlords about?
Yeah, I mean, we had a conference call about a week and a half ago, and it involved a number of landlords and different participants, and all the landlords were opening up their files, calling their tenants and saying, where are you? What are you doing? Trying to reach out to the tenants. And after that, I talked to a couple landlords, like, I've called, emailed, and texted this tenant 3, 4, 5, 6 times, got nothing. I said, well, then we know where that file falls in the pile here, and we line it up for when the moratorium ends. Most landlords I'm talking to don't want to evict their tenants. They want to get them caught up. They want to work with them and get things going. Most are doing things with late fees, waiving them. They're taking steps to do a bunch of different things. And it might be a good opportunity, just because we're running out of time. Let me jump in, is that there is a program in the works in York County. It's being put on by the York County Community Foundation. It's also being part of the Community Progress Council, CPC. I think the materials are attached to the end. There we go. Here's our slide. But there is a pool of money that they're generating, and it's for 2 purposes. One is to help with food and hunger issues, and 2 is with home security and stability. So there's a website here. It's yorkcpc.org/take action, or actually / I guess, but take action. There's going to be some processes for landlords, tenants to get involved and start looking at some matching, some different scenarios, perhaps where there'll be money grants to help the tenants get caught up, stay caught up, get on a plan, and not get evicted. So, there are a lot of things happening. As this develops, we're going to be notifying a lot of different players in this field of it. But this is a great website for everybody on this call to be knowing about and to use as a resource.
And in the bigger picture, just real quick to hit on, in the larger scheme of things, right? So we have the unemployment system has been backlogged, perhaps in the coming weeks with the introduction of some of the unemployment assistance programs and taking applications. And processing all the other claims, we might start to see the unemployment system pay out and some money flowing there. You've got the economic stimulus money coming down. There's also streams of money coming down to the states and localities from the federal government, from the CARES Act, et cetera, that might start making its way down to different communities. So, to the extent that there is any way to kind of hold on here, there may be some light at the end of the tunnel. Obviously, that's not going to apply across the board, but if anybody can hold out, there may be some workability there.
Okay, well, thank you very much, gentlemen. We're going to move into the questions phase of our program here today, and we'll leave this for whichever or if both of you do wish to comment on this. I'll do my best to summarize some of these questions. The first question we have pertains to a landlord who had begun the eviction process before all of this happened, before the court closures and the orders. So their tenant has been now in there for a period of time. Once the moratorium is listed, the question is, are they able to seek additional restitution for the period of time that they've been in there in order to compensate them from before the crisis?
Sure, I'll jump on this one. So let's use the hypothetical that I filed at a magisterial district court, and my filing was filed prior to the stay, was properly set up, but we haven't had our hearing because of the stay. If a landlord files a landlord tenant complaint with the magisterial courts correctly, there's a box on the left-hand side about a third to the halfway down where I always say check the box for rents due and owing at the time of the hearing. When they then get their rescheduled hearing with the courts, they'll be able to amend and bring all the dollars current that are back or owed from the prior time that they filed, and then they can keep this thing moving.
I think the other aspect of that, Kurt, because I think this was a question I'd seen throughout there, is what do you do if you'd already been through the whole process? You got a judgment, you had an order for possession that was scheduled for eviction, but then the moratorium took hold. And so now you've already gotten your judgment, you've gotten your order for possession, sure, but now that person's been in there for the past couple of months where they're not paying rent, there's no utilities. What would so as soon as the moratorium opens up, that person's going to be evicted. But what do you do about the time frame during the moratorium?
Yeah, I mean, there's really a couple options. Number one would be you file a second landlord tenant action for all the back monies not included in the original filing, not covered by that. That's one option. Number two would be you wait and just follow through your lockout and make sure you're locked out. You can always bring a civil, or the option is a lot of times you may realize that a lot of tenants have no resources, and you may need to have the discussion if it doesn't make sense to spend another $200 filing fee, the time and effort of filing to get a judgment that may never get collected. I'm having those kind of discussions with my clients because they are getting concerned about their cash flow and things of that nature. If you file a landlord tenant, you had your judgment, it's coming into lockout time, your monies are only through March at that point. If the tenant pays that, they could very well be allowed to stay in the property. There's an eviction called a pay and stay or a conditional possession. That is very much the norm out of the magistrates, that the magisterial district orders are saying if they pay it in full, they get to stay. So that is the one thing that when I advise a landlord, it's let's look at, do we jump in and file our second landlord tenant? Because if we wait 3 more weeks to the lockout date, we're now into mid-May and May, it's going to be a long time period to get to that next hearing, and we're now 2, 3, 4 months down again. So some landlords may take the position of, let's hope they pay, let's work with them. And if they're hearing from the tenants, that makes this decision easier. When there's nothing they're hearing from the tenants, my guess is they're going to run and file.
The next question we have is an interesting one because in preparation for today's presentation, it's a conversation we actually had, the three of us. Now, the order as it currently is expires on May 11th. And one of the questions is, well, what happens on May 12th? Because all of these deadlines have been extended. And there's the probability that May 12th is a mad rush to file things. So the question presented is, can the 10-day notice for non-pros, meaning a landlord's failure to file a complaint in the Court of Common Pleas, be filed with the prothonotary on May 12th?
So again, this
I
is where I'm
suspect
gonna,
what they're asking here is prior to the court closures, there was, or at least during the closure, there was this deadline for the landlord to file the complaints. So presumably they have until May 12th. It hasn't been filed up to this point. Can I, as a tenant, file a non-pros?
yeah. So the term of art here to keep in mind is tolling, okay, toll or TOLL. There was a tolling of all filing deadlines during the course of the moratorium, right? So for instance, if a landlord had filed a complaint at the end of March, and you as a tenant then would have had 20 days to respond. Now keep in mind, this is in common pleas. If you would have had 20 days to respond at that point, your deadline was tolled, so it was essentially suspended until the end of any given order. So now, up until the Supreme Court's order of the other day, those deadlines were all being tolled until the first day that the court opened back up. So I'll use Dauphin County as an example. Dauphin County issued an order before the most recent Supreme Court order that had the court closed through May 31st and explicitly stated that all filing deadlines were suspended or tolled during that time frame, such that anything that needed to be filed during that time could be filed timely, so long as it was filed on or before June 1st, the first day that the court opened up. So even though your 20 days in my hypothetical would have expired sometime around, the end of March or what have you, if the landlord had filed the complaint at the beginning of March, that you would still be able to file your answer timely so long as you filed it on or before June 1st. Now, I'm going to go back, though, to the disclaimer that I threw out at the beginning because of the most recent Supreme Court order and that creating a kind of this wrench being thrown into the whole system now with the lack of guidance. And I say that because the most recent Supreme Court order says that the suspension of all these deadlines was only through May 11th. So now the notion and understanding is that if you're in a county where you were just simply following the Supreme Court order, even though the Supreme Court order closes everything down through the end of May, the Supreme Court order made it clear that you need to file these things on or before May 12th in order for them to be timely. So now that's another problem that we run into, and this goes back to what I'd said before about really needing to check with your locality and making sure that you're understanding what it is that your county is doing in particular, because you may very well have some counties that say, yeah, you got to get in here and file per the Supreme Court's deadline, and you're going to have other counties that may say, no, we've extended it out beyond that, and so you have longer. And it really just depends on what's going on in your county. Any thoughts on that, Kurt?
Yeah, I mean, I was sort of hoping it was the other way around, and I filed a complaint and hadn't had an answer from a tenant versus a non-pros, but
I think it's the same concept. But whatever it is that you're filing, the important thing to just know is that there had been this suspension, but since it ends at the end of whatever the moratorium is, and it's just important to know what your moratorium is in your particular county.
yeah, I think you're going to have to pay attention to all that.
All right, our next question pertains to the CARES Act. And in this instance, a tenant is receiving their income from SSI. Does the CARE Act pertain to them?
So the CARES Act does not apply based on income of any given tenant in particular. The important thing to note and be leery of for the application of the CARES Act is the type of housing in which the tenant resides. Now, in probably a majority of circumstances, if your only income is Social Security, you may very well be living in subsidized housing that's subsidized in some form. So I would imagine that, I don't want to put a number on it, but let's just say that probably the vast majority of Social Security recipients are probably residing in some type of subsidized housing. So it may work out in that way, but that's not the determining factor. You're not looking at the tenant's income in particular, because that doesn't come into question. It doesn't matter what the tenant's income is. What matters is, are they living in what's that covered housing, that list that we have provided you?
You know, for the record, I have to just say it this way, Matt, I agree with you.
There you go.
You won't hear that too
You
often.
realize we are recording this, right?
I know, I had my caveat is doesn't happen too often, I guess.
Let's move on really quickly before he takes it back.
Okay, fair enough. Our next question, and I read this to mean not federally subsidized. So the scenario here is a tenant's currently working during the pandemic and hasn't shown any type of hardship. Can the tenant still withhold rent from their landlord and use the pandemic to get out of paying?
Sure, I'll answer that. There's not a single order, statute, directive by anyone saying you don't have to pay. So I don't see that that's a scenario that anyone should be allowed to just get out of payments. One of the things that it was a question we saw earlier was about the strikes. I have not heard much about rent strikes in Central PA. Checking online, I know it's New York, it's Philadelphia, and it's Los Angeles that are planning them for tomorrow. But you know, the problem is these rent strikes, it's not just mortgages that the landlords have. It's maintenance, it's taxes, it's insurance, it's utilities. It's a whole bunch of different scenarios that they have expenses-wise. So simply saying they don't have to pay their mortgages is only part of the puzzle for them. So there's not a single thing out there that gives a freebie in this time period to anybody.
So let me ask you a follow-up question regarding that, Kurt. During this moratorium, and someone has financial hardship or what have you, how does late fees and interest play into all of this?
Well, the late fees, if it's a protected housing under CARES, are going to be prohibited. They're not allowed to charge those if you're the appropriate tenancy. I can tell you from discussions with most landlords I'm speaking with, almost all of them have waived late fees during this time, trying to work with tenants, trying to get the tenants to be responsive and do their portion as well.
And then I'll return the favor to you, Kirk, because I'm going to chime in and say that I agree with everything that you'd said there. The only thing I would add is I think that if you have a landlord-tenant situation where the landlord is entitled to charge late fees during this time because they're not a covered property, I do think, or I'm hopeful, I guess anyway, that on the back end, if you get before a judge and the tenant has a plausible explanation, I think you might end up having a tough time getting the judge to agree that the late fees should be assessed. But they can be assessed so long as it's a non-covered property. And again, I go back to touch on your first question there, Glenn. I go back to the slide, that kind of parting shot slide that I had there about, what should tenants be doing? What are best practices? Again, I mean, you can certainly hold on to your, you can always hold on to your rent and not pay it, but there is nothing that has been put out there that says that you're ultimately not going to owe it. So you can save your rent and you can kind of essentially take the protection of the moratorium because you're not going to be evicted during the moratorium, but at the end of the day, you're still going to owe the money and your landlord's still going to be able to take legal action against you if you don't pay.
Okay, we're going to ask our final question, and apologize we don't have time to get to everybody's questions. We're going to do our best in follow-up to try to answer questions. So if you have registered for this program here today, we're going to be sending out a link later on, which has the slideshow and quite possibly is also going to have the video content as well. We also ask you to please stay for the conclusion of this, as there's a survey at the end of the program that is necessary for us in our process of obtaining distance testing so that we'll be able to offer continuing education credits. So our final question, I have to look over my right-hand shoulder here, is we've got a tenant who is behind $1,300 in rent before the pandemic started. And now with May coming up, they're going to owe over $4,000, hasn't responded to any questions. So it sounds like some of the scenarios that Kurt had been talking about. Should I file for eviction on May 19th? Now, I'm going to caveat that by, again, we're not providing legal advice here, and we provided a disclaimer in the beginning. We'll provide a disclaimer at the end, but do you have any comment regarding this?
Sure. I mean, I'll jump in. It's if the tenant's not showing any effort, they're not had any communication, they're simply living without paying, I'd be filing as soon as I'm permitted under whatever my jurisdictional rules are. So 19th actually would be a week late potentially. I might come in more like, 12th, 13th range time period. Get it sooner and going. If they're not going to pay and they're not responding, absolutely, I'd be filing.
And I'd be expecting that from the tenant's perspective.
Okay, well, that concludes our portion of the questions. Again, we thank everyone for the questions. We have our final poll that pops up here. So we ask you to please do participate in that. And as you are doing so, we would like to thank both of our guests, Kurt Blake and Matthew Rich, for their participation in this. And we'll thank MidPenn Legal Services, who Matt is here representing as well, along with the York County Community Foundation. Of course, this is Legal Lines. I am your host, Glenn Smith, and Legal Lines is supported by the York County Bar Foundation. You can learn more about us at www.yorkbar.com.